Your Honor,
Yes, sir.
before you call the case you think I might be here on, I've had a chance to talk to Miss Seeley. She was in the MIDC waiting room, and I explained the charges to Miss Seeley. However, she would like to know under which jurisdiction I operate. I've explained that I'm a criminal defense attorney and I don't operate under any jurisdiction, so I don't think she's seeking the services of an attorney at this time, and the court may like to speak with her.
Before a single charge is read, before the judge can even finish a sentence, this courtroom is already heading for chaos. What you're about to see is not just a routine traffic and misdemeanor case. It's a masterclass in courtroom obstruction, sovereign citizen rhetoric, and a defendant who believes the law itself must bend to her personal definitions. On one side, you have the court, calm, procedural, and operating exactly as Michigan law requires. On the other, Bun Itaselli, a self-represented defendant armed with buzzwords like jurisdiction, common law, and due process, but seemingly allergic to straight answers. This case stretches back months, bouncing between judges, hearings, and missed court dates. At every turn, the same strategy: refuse to engage, demand impossible legal explanations, and declare victory whenever the court refuses to indulge nonsense. Today's hearing is supposed to be simple, an arraignment and pretrial. Instead, it becomes a showdown over authority itself. Watch closely how the judge stays measured. Notice how the court-appointed attorney quietly steps back. And pay attention to how repeating the same question doesn't magically change the law. The real twist: this isn't going to end where she thinks it will. Stick around, because this courtroom spiral has consequences.
Thank you, Mr. Batar.
You're welcome, Judge.
These are 23HR0457A, B, and C. These are Huron Township versus Bonita Seeley. Ms. Seeley, were you able to hear Mr. Batar just now?
Oh, first of all, are we on the record?
Yes, ma'am.
Okay, are we under penalty and perjury?
Are we on what, ma'am?
Under penalty and perjury, is he willing to swear in?
I'm sorry, ma'am, I can barely hear you.
I said, is everybody willing to swear in under penalty and perjury?
Ma'am, we're not taking testimony as of yet. Today is the day and time scheduled for the pre-hearing and adjourned arraignment pretrial in these matters.
It still has to be placed on a record. He still has to be put under penalty and perjury because he's swearing to an alleged crime against me and holding me accountable. So even though this is just a hearing, it still has to be put on notice for the public as well.
And right here, this is the first massive red flag. When someone asks a defense attorney what jurisdiction he operates under, they are not asking a legal question. They are reciting a script. This is classic sovereign citizen ideology, where they pretend attorneys, judges, and courts are independent corporations that must declare jurisdiction like some kind of legal Pokemon battle. In reality, criminal defense attorneys don't operate under jurisdiction. They practice within it. The court's authority comes from statute, not personal consent. The moment she rejected counsel over that answer, she effectively chose to play this game on hard mode, without understanding the rules, the penalties, or the risks. And as we're about to see, that choice will echo throughout the entire hearing.
Ma'am, today is the day and time scheduled for the pre-hearing and the arraignment pretrial. Would you state your name for the record, please?
Bonita Seeley.
Ms. Seeley, Mr. Batar is the court-appointed attorney assigned to this courtroom for the day. He's indicated that you don't wish to engage his services. Is that correct?
No, let me explain my position. I asked him a simple question about jurisdiction. That's why this hearing has been readjourned for today, because the last hearing, none of the attorneys could answer the question in regards to what jurisdiction that we're operating under. So they want to proceed without addressing the jurisdiction, which is a violation of due process. So in order for him to be represent me on any public record, I have to understand what jurisdictions he's operating on.
Ms. Seeley, if you do not wish to use the court-appointed attorney, and you confirm as much to the court right now, Mr. Bitar can go back, ma'am, Mr. Bitar can go back and do other things that he needs to do this morning. Do you wish to use Mr. Bitar's services, or do you wish to represent yourself this morning, or do you wish to retain counsel through some other mechanism?
Under what charge, under which jurisdiction, and then who's bringing the charges against me?
Ma'am, there were citations issued against you in Huron Township for limited access speeding 11 to 15 miles per hour over the posted speed limit. That's a civil infraction. There's count 2, no proof of insurance. And there is the misdemeanor of driving while license not valid or improper license. Do you wish to use the services of the MIDC attorney, or do you wish to represent yourself this morning, or do you wish to retain counsel?
Who are the parties bringing this claim against me? It's a simple question.
This exchange is where confidence meets confusion. Demanding everyone be sworn in under penalty and perjury sounds official, but it reveals a fundamental misunderstanding of how hearings work. Attorneys don't testify. Judges don't swear themselves in. And pretrial hearings are procedural, not evidentiary. The court is already a court of record, meaning everything said is preserved, ironically accomplishing exactly what she claims to want. What's fascinating is how often sovereign citizen arguments rely on misusing legal language just convincingly enough to sound authoritative, while collapsing under even basic scrutiny. The judge doesn't mock her, but he does correct her, and those corrections matter. Because when you choose to represent yourself, every misunderstanding becomes your responsibility alone.
I answered your question, ma'am. I answered your question, ma'am. I answered your question, ma'am.
And could you re-answer it? Because I didn't hear it. Who's bringing the charges against me?
The citation that was issued to you was issued by an officer from Huron Township, Freddie Yono. It's the citation that was issued, is signed.
So it's Freddie.
It has his name and his ID number. Ma'am, my question to you is, do you wish to engage the services of the court-appointed attorney, or may I release him to go back to do some other work?
Wait a minute, I have questions before I can answer on. You're trying to get me to
no, ma'am. No, ma'am.
Yes, it's a,
no, ma'am.
It's a due process violation. Objection. Yes.
Miss Seeley, this is the third and last time I'm asking you. Will you be using Mr. Bitar to represent you this morning, or do you wish to retain your private attorney, or do you wish to represent yourself?
I need to understand what jurisdiction we're under.
Mr. Bitar, you may return to your breakout.
This is the core of her entire defense, or what she believes is one. Jurisdiction fixation is the sovereign citizen cornerstone. The irony? Jurisdiction has already been established the moment she was cited, summoned, and appeared in court. Michigan statutory courts don't need to justify their existence to defendants. And insisting that jurisdiction must be understood before counsel can represent you is legally meaningless. Attorneys don't require client approval of jurisdiction. They operate under licensure and statute. What's really happening here is stalling. By refusing to answer simple yes or no questions, she forces the court to repeat itself, draining time and patience. Judges tolerate a lot, but they don't tolerate obstruction disguised as confusion for Eve.
Rooms to meet with other potential clients. Thank you.
Thank you, Your Honor.
Your Honor,
Ms. Seeley, do you intend to represent? I'm sorry, Ms. Foley Carter.
I just want we started this case back in July. Ms. Seeley attended her first pretrial. She demanded that the case be dismissed. I declined. I asked that the case be set for a bench trial. Ms. Seeley objected, and Magistrate Hinman advised her to file a motion stating her objection. Since then, she asked Judge Green for her oath of office and then didn't appear for the court dates before Judge Oakley. So this case has been going on for quite some time with no resolution.
Because I'm asking a question and it requires a rebuttal and it's being ignored. You cannot violate the due process. This is a hearing, and any questions that I have needs to be answered. You don't get to sit in the capacity of government and ignore the questions that the people have. Someone's bringing a claim against me, and my only question is, Are we dealing in a commercial or a common law, also known as a record of law, court? That's simple. So are we in a common law?
Notice what the judge keeps doing here, offering her options. Use the appointed attorney. Represent yourself. Retain private counsel. That's due process in action. But instead of choosing, she keeps reframing the question. This is a tactical mistake. Courts interpret refusal to answer as refusal to cooperate, not as some clever legal maneuver. And while she believes she's preserving her rights, she's actually waiving protection. Because once counsel is dismissed, every procedural misstep belongs to her alone. The judge isn't confused. The charges are clear. The parties are identified. What's missing is compliance, and the clock is absolutely ticking.
Marianne, a in-person bench trial date in this matter, please.
Objection. Objection. Are we in a common law court? Yes or no?
January
Case
23rd
dismissed.
at 11 o'clock.
Case dismissed. Case dismissed because you refuse to rebuttal to the question regarding jurisdiction. You cannot proceed without honoring the jurisdiction. You cannot be in the
Ms.
capacity
Seeley?
of a... Yes.
The misdemeanor matter and the two civil infractions that are traveling with it that were issued on April 26, 2023 will be set for an in-person bench trial in courtroom number 1.
Objection. I will not be showing up. Objection. I will not be showing up. You refuse to answer the question of jurisdiction. You're trying to get me into the courtroom so you can take me against my will and lock me up in a cage like an animal. Objection.